Good afternoon, everyone, and welcome. Hope you all are keeping well and safe. Dalal and Brocha, as part of its investor outreach program, have associated with Khaitan and Company in today's session to take us through some of the legal aspects faced with some of today's pressing issues like the force majeure clause on commercial contracts, employment and regulatory compliance issues. Let me start with a brief introduction on Khaitan and Company. Founded in 1911, Khaitan and Company is one of the oldest and largest Indian law firms, combined with a rich heritage of over 100 years with a modern and cutting-edge practice. The firm offers full-fledged legal services and solutions to domestic and international clients. Khaitan and Company has over 700 professionals, including 150 partners and directors, with offices in Delhi, Mumbai, Bangalore, and Kolkata. I will now hand over the floor to Neha to introduce our esteemed panelists. Over to you, Neha.
Thank you very much, Nilay, for that, and a very good afternoon to the Dalal and Rocha team. It is our pleasure indeed to be here, and thank you, Nilay, for that very wonderful introduction of Khaitan and Co. My name is Neha Karande, and I'm a director with the strategy group at Khaitan and Co., which, as you heard, is one of the most prominent Indian law firms. Most of us have been actively working from home in this new normal, and COVID-19 has definitely done its tricks on us in terms of it being one of the most dangerously growing pandemic that has afflicted the entire world. In addition to the daily lives of each one of us, this uncertainty has severely impacted the survival of most businesses and is now raising considerable questions on their sustainability. You will appreciate that as a law firm, we have been getting a variety of complex questions affecting businesses in one form or the other. And today, like I said before, we are very, very pleased to be here with our esteemed domain specialist partners to discuss some of the critical areas afflicting businesses, the legal and regulatory interpretations, and likely solutions to address a few of these situations. Kindly note that all our partners have connected remotely, and you may have to bear with us for technical glitches, if any. Should the link of any speaker fail, we will move on to the next one. We plan to cover this presentation over the next 45 minutes, and we will take questions at the end of every topic. Please keep typing the questions in the question box that is available to you on your screens, and we will try to take these at the end of each section, and hence you do not have to wait till the end to try and pose your questions. With that, let's please start the session today, and I would request Tejas to kindly move to the first slide. As mentioned by Nilay earlier, there are many issues that have been bothering us in these tough times, and we would like to cover and summarize these issues in the following 4 sections. The first one would be contracts, which will include the force majeure clause, and also we will touch upon section 56, which is the frustration clause. This will also talk you through what the do's and don'ts of invoking FM, since it would be the first time for many of us. The next section will cover the employment laws, and this will talk about various aspects of the work from home policy, which is currently what most organizations have undertaken. We will also walk you through what the new norms are in terms of employment, and what the employers and employees should be thinking about in this new normal. The next section will be talking about the debt servicing issues. Each and every one of us is facing this. All organizations tend to be leveraged, and it's important that all of us also understand what the RBI is doing for us, what we should be doing as organizations from a debt perspective. And last but not least, we will touch upon the corporate governance issues and talk to you about how organizations should start thinking about corporate governance in these tough times. I will now introduce you the keynote speakers for the day. The force majeure section will be covered by Kingshuk Banerjee, and he is our partner in the dispute resolution practice. Harsh Parekh, who's our partner in the real estate practice, will talk to you about real estate issues, real estate agreements, lease rentals, and things like that within that spectrum. Anshul Prakash, our partner in the employment and labor and benefits practice, will talk to you about the key employment laws. And Abhimanyu Bhattacharya, who's a partner with the capital markets and securities regulation practice, will talk you through the corporate governance issues. With that, Kingshuk, may I please offer you the mic and ask you to please take the first section on force majeure. Kingshuk, over to you.
Thank you, Neha, and thank you, the Lion and Rocha team, for having us here. So, as Neha mentioned, I will try and give you a brief overview, generally speaking, on force majeure clauses. And I think over the past few weeks, most lawyers have been answering questions relating to force majeure clauses, claims, and notices. So, in the course of the next few minutes, we'll give you a general overview and really some practical insights on force majeure based on our recent experiences. But before we talk about force majeure clauses, I think it's important to lay the foundation for the discussion. Really, force majeure clauses, it's important to understand, refers to a clause in a contract. And when it comes to contracts, the law expects parties to really fulfill their obligations under the contract. The court expects parties to fulfill their obligations under the contract. Non-performance of obligations could expose parties to various monetary and operational risks. And this is important to bear in mind when discussing or dealing with the issue of force majeure clauses. Having said that, in the wake of COVID, I think most businesses have been severely disrupted. It goes without saying. A lot of individuals and entities are finding it difficult to fulfill their contractual obligations, and this is really where a force majeure clause comes into play. FM clause, simply put, is a clause in a contract which excuses a party from performing its obligations under the contract due to the occurrence of certain supervening events. While you can see on your screen a definition of force majeure as contained in the Black's Law Dictionary, but really what FM means to each of us would depend on the contract and the language of our contract. That's important to bear in mind. Can we move to the next slide? So over the past few weeks, a lot of clients, especially non-lawyers, have been inquiring on, is there some systematic way of dealing with a force majeure situation? What is it that we need to look out for? Where do we really start? And what we've tried to do here is list out 4 critical points or questions that we need to ask ourselves really when we are dealing with a force majeure clause. Question number 1, and perhaps the most important question, is, does my contract have a force majeure clause? Because if my contract does not have a force majeure clause, I may not be in a position to make a force majeure claim under the contract. I may then need to look to Section 56 of the Indian Contract Act to see if there is some sort of legal recourse. But under the contract per se, I will not be able to make any claim unless I have a force majeure clause in the contract. This is important to understand and be aware of. Second, if I do have a force majeure clause in the contract, I need to look out for the words pandemic, epidemic, government action, or government order in the definition of the force majeure clause in my contract. Because if you have these events in the current context, they become relevant and it becomes easier for us to really make a claim of force majeure, and there is then no room for interpretation or debates. But that by itself is not enough, because the next point that you need to bear in mind is that one needs to correlate the event, the force majeure event, with your obligations under the contract. So question we need to put to ourselves is, do these events really impact, prohibit, or impede my performance under the contract? That's important. So there must be a force majeure event and it must prevent or affect performance under the contract. And finally, a point which is linked to the introductory point that I made, that when you enter into a contract, parties are expected to fulfill their obligations under the contract. And really an extension of that is point number 4, that is there something that I could have done to really prevent the impact of the force majeure event on my obligations under the contract? I am expected to do what I can to really mitigate or so to say dilute the impact of the force majeure event on my performance? And really, if the answers to the first three questions are yes, and the last one is a no, it is possible for us to perhaps, successfully claim a force majeure event. Having said that, it's not as straightforward as that. You could have a situation where your force majeure clause is not there in the contract, and we'll come to that situation in a bit. But it's also possible that the definition of force majeure may not have pandemic, epidemic, or government action or lockdown specifically included. What then is the course forward? And we'll deal with that in the next slide. So what we've tried to do here on your screen is really categorize definitions of force majeure that we've seen in our experience into three broad distinct categories, even at the cost of generalization. On the extreme left, you have an example of a definition which is very wide, generally worded, and what we in legal parlance call an inclusive definition. If you have a definition which is as wide as this, it is possible to argue that a pandemic or an epidemic is specifically included in this definition. On the other end of the spectrum, you have a definition which is what we call exhaustive, a definition which the events that am I audible?
Yes, Keshav.
Yeah. So on the other end of the spectrum, we have a definition which is exhaustive, which lists out the specific events that we intend to really cover in our force majeure clause. If you have a definition like this, then there is no room for any interpretation, no room for debate. And between these two broad spectrums, you have a definition which is both inclusive, which is widely worded, but at the same time, it does list out certain specific events. And really, if you have a definition like this, in first blush, it may seem that this covers all possible events. But what we've seen, if you have a definition like this, is courts apply the principle of ejusdem generis. And to understand this better, let's really focus on this example. And I'm going to read it out for you. Force majeure means and includes lightning, earthquake, tempest, cyclone, flood, war, strikes, and all other events beyond the reasonable control of the affected party. Now, the underlined words there is what we call a catch-all provision, and much will turn on how courts really interpret this catch-all provision. And what we've seen in the past, both in India and outside India, is courts really giving meaning to this catch-all expression by reference to the words that are used before it. What do I mean by this? Let's assume that your obligations under the contract is affected by a tsunami. A tsunami is not specifically listed in your definition, but the court is going to say that, look, a tsunami is similar to a flood or a cyclone, and therefore it's really something that the party is intended to cover. Similarly, a terrorist activity is something a court may say that, look, is covered because it's akin to a war. But it's quite possible for the court to come to a conclusion that a pandemic or an epidemic or a government action, which is quite distinct from any of the events that are listed out, are not covered in this definition. Having said that, I think we are faced with unprecedented times, and really it will be really very interesting to see how courts approach this kind of a definition going forward. In the next slide, I will touch upon some other considerations that are really relevant when you're looking at force majeure situation. And first and foremost, look out for exclusions and exemptions in your contract. It's possible that, like you have specific events listed out in your definition, you may also have certain events excluded. We have seen contracts with pandemics specifically excluded, surprisingly. You may also have a situation where certain obligations under the contract, like payment obligations, for example, which may be specifically excluded from the force majeure clause. So a good idea to read the entire contract as a whole. Don't simply restrict your reading to the force majeure definition or the force majeure clause. A second important consideration is that, look, we need to demonstrate, or rather we are required to demonstrate that we are unable to perform our obligations under the contract. because of the force majeure event. Uh, Commercial hardship or commercial inconvenience by itself is not enough to really trigger a force majeure clause. Many ask if this is a good time to renegotiate the commercial terms under the contract because it's unviable for us to now really fulfill our obligations under the contract. Strictly speaking, and subject to the terms of your contract specifically, typically a commercial non-viability or inconvenience will not be enough to trigger the force majeure clause. Finally, we should be aware of the consequences. It's quite possible that if we don't perform our obligations under the contract under the pretext of force majeure, and if we fail in really establishing force majeure, we may ultimately expose ourselves to operational and legal risks like claim for damages, a claim for specific performance. That's something to be conscious of when you're invoking a force majeure claim. Uh, Having said that, if you succeed in making a force majeure claim, then really the consequences will depend on the provision in your contract. The contract may provide for suspension of performance, delayed performance, deferment, or even termination for that matter. So really, consequences will be dependent on the language of your contract. Up next, what we'll try and do is, so over the past month or so, we've seen a number of clients, um, face force majeure situations. We've seen clients deal with force majeure situations, and some key pointers and strategies to really resolve a deadlock is what we'll quickly run through on this slide. One, I think, key point is it's good to be specific when we are invoking a force majeure clause. Also important that we follow the procedure under the contract. These 2 points we should keep in mind. Specificity is really important because we've seen contracts or claims which simply state that, look, there's COVID-19, there is disruption, and I can't perform my obligation. That by itself may not be enough. You need to specifically set out what the force majeure event is and what is the obligation that is impacted. Good to be specific. Some strategies that clients have adopted to resolve, a deadlock. Um, One is, look, do check if your activity under the contract is exempt under the government lockdown orders that have been passed, 24th March order and then the 15th April order. Do look at that because that may simplify matters. If your activity is specifically covered, it makes it that much more easier to really claim force majeure. However, if your activity is exempt, you may have to be more specific and really clarify why you can't perform your obligations under the contract. We've seen some clients with weak force majeure claims really combine the force majeure claim with a palatable proposal, commercial proposal, the proverbial carrot, dangling the carrot, so to say. And we have had situations where counterparties, though they've disputed the force majeure claim, but have accepted the commercial proposal, and parties have been able to resolve the dispute. Another important point is that when we make force majeure claims, we often get caught up with our own performance and our own inability to perform, but we often miss a vital fact that even your counterparty may not be in a position to perform. So good to keep that in mind, keep a lookout for that, and if really that is the case, a good idea to bring that up in discussions as well when you're negotiating out of a force majeure situation. We've seen a lot of companies, individuals relying on the government notifications that have been passed over the last few months, starting with the Ministry of Finance notification of 19 February to say that, look, the government has said this is a force majeure event and therefore it's a force majeure event. Good to understand that, look, these notifications were issued in the context of specific classes of contracts. So the Ministry of Finance notification was in the context of the public procurement contracts, and they may not necessarily apply to private contracts. So relying on these for persuasive value perhaps is okay, but they don't have the force of law insofar as private contracts are concerned, generally speaking. We've also interestingly seen parties arm themselves with legal opinions when negotiating force majeure clauses, and it has worked. Needless to say, when you're responding to a force majeure claim, You can ask for evidence. You're well within your rights to say that, look, you need to prove that you're impacted by the force majeure event. So please do ask for evidence. Uh, uh, Interestingly, also, we've seen some parties who have exchanged, a number of correspondences and have reached a deadlock. They've really taken recourse to mediation and conciliation to resolve a force majeure situation. Very interesting, and time will tell if this is a recourse that parties will more frequently now adopt going forward. We can move to the next slide. I will very briefly touch upon Section 56 of the Indian Contract Act. I take you back to the first slide where I mentioned to you that it's quite possible that you may not have a force majeure clause in your contract. You may then really need to take recourse under Section 56 of the Indian Contract Act. Section 56 of the Indian Contract Act provides that after the contract is made, if it becomes impossible or illegal for the parties to the contract to perform their obligations under the contract becomes void. In first blush, this seems to be an automatic recourse available to parties in the given situation, but it's important to understand that the language of Section 56 requires or contemplates a permanent impossibility of sorts. So if you're temporarily unable to perform your obligations, Section 56 may not come in handy in those circumstances. So the threshold of invoking Section 56 is extremely high. You need to establish permanent impossibility or permanent illegality, so to say. Also, just briefly, why 56 comes in the absence of force majeure clauses. So Supreme Court of India has said that where parties have negotiated a force majeure clause in their contract, and really the force majeure clause is attracted to the facts and circumstances of the case, it is not open for those parties to then look outside the contract and invoke Section 56, and that is where that's important to understand. So 56 comes in where you don't have a force majeure clause or where it's not attracted to the facts of your case. And with that, I'll conclude with what we refer to as lawyers as a developing sort of post COVID-19 jurisprudence. We can just move to the next slide very quickly. So historically, courts have taken a narrow view of the matter. Courts will interpret contracts to really give effect to the parties' bargain. Courts will expect you to perform your obligations, and courts will try and really get parties to perform their obligations. But that's in the past. The current situation is unprecedented in many ways, not something that we would have envisaged. Really, we've seen governments come out with all kinds of notifications to say that, look, this is a force majeure event, whilst those are applicable in the facts and circumstances of the cases that they really cover. But it is a reflection in many ways of societal perception of the given situation. And really, with that, we now very quickly come to a few judgments that we've seen that Bombay High Court and Delhi High Court have had the occasion to deal with in the context of force majeure. So the one Bombay High Court judgment that we've seen, it's really an ad interim order, not a final decision, so to say. But Bombay High Court was pretty much spot on and said that, look, in the facts of this case, force majeure does not apply. This was a case where a purchaser of some goods, invoked the force majeure clause to say that, look, I am not in a position to make payment, and therefore please excuse my payment obligation. And the court said that nothing doing, you have ordered the goods are in transit, and you will now need to make payment. The force majeure claim is not tenable. Largely following the first principles of force majeure and applying the first principles of force majeure. Delhi High Court, though, has taken a view in Halliburton versus Vedanta that, look, the lockdown really constitutes a force majeure situation. This was a case where a party which had furnished a bank guarantee to secure performance of its obligations under the contract, which party was not able to perform its obligations because of the lockdown, and was apprehensive that the counterparty would invoke the bank guarantee, went to the Delhi High Court and said that, look, please protect me. I am not in a position to perform my obligations, but I at the same time don't want my bank guarantee to be invoked right away. And Delhi High Court in that context granted an ad interim injunction and said that the party really was impacted by the lockdown, and therefore force majeure is attracted, and protection was given to that party. Uh, but I must caveat this by stating that both all three orders here that I've referred to are ad interim orders. They were passed in the facts and circumstances of each case. One should not rely on this, out of context. Please do be conscious that a court will decide each matter on its own merits. Having said that, these judgments do sort of give you a sense of what the trend is likely to be going forward, at least during the lockdown. With that, I'll request Harsh to take over and shed some light on the real estate aspects of force majeure.
Thank you, Kingshuk. Good afternoon, everyone. So, as I think Kingshuk mentioned about force majeure and frustration, similar principles also apply in the constructs of real estate contracts, be it a lease, leave-in license, any commercial contract insofar as real estate is concerned. Before we get into what happens if there's a force majeure clause in a real estate contract, we look at a situation where if either a commercial lease, leave-in license, or a business conducting agreement does not have a force majeure clause, then what does the law state? So in case of a lease, if the lease deed is silent on the force majeure aspect and there is no force majeure clause, then one needs to look at the Transfer of Property Act, that is especially section 108 of the Transfer of Property Act, and not section 56 of the Contract Act, which you just heard, because this is a settled position of law that only and only in case of lease documents, commercial leases, section 108 of the Transfer of Property Act applies. Now, what does section 108 of the Transfer of Property Act state? It merely gives rights in case if a property is damaged or destroyed because of any act of God or irresistible force. It does not envisage a situation which is as present today, that because of a lockdown or any reasons or event beyond control, parties are unable to access premises. And therefore, in a nutshell, if your lease document does not have a force majeure clause, you would not be able to take any statutory protection and seek suspension of obligations of payment or rent or any other charges under the contract. Similarly, in case of a leave-in license or a business conducting agreement, if your leave-in license is silent on force majeure, there is no clause, then as Kingshuk mentioned, you would need to look at section 56 of the Indian Contract Act, which typically deals with frustration of contract. And as you would have heard, the bar of section 56 is extremely high. You need to demonstrate a permanent disability, impossibility to perform, which basically vitiates your contract. So therefore, even in case of a leave-in license, if you have a 5-year, 3-year term and 60 days, 70, 90 days inability to access premises for conducting business may not stand the test of section 56 as is laid down today by the courts in India. Going forward, how courts may deal with this is a separate issue, but today as the law is present today, it may not be possible to invoke 56 even in case of a leave-in license, to say that it's now become impossible. And another thing which needs to be borne in mind is 56 talks of a complete frustration and termination of a contract. So therefore, even in case of a leave-in license, you cannot seek suspension of payment only for 3 months under 56. If you were to try it invoking 56, it would lead to a complete termination and not a partial suspension. Now, looking at if you have clauses in your agreement, even be it a lease deed or a leave-in license, you would be confined only to the eventualities and what is contemplated in your contract. You cannot go beyond that, and that's a settled position of law again. So therefore, it is critical to ascertain what is it that the force majeure clause entails. Whether firstly, at all, does it entail any events beyond control of parties? Does it entail pandemic, epidemic? So it's important to know what is it that constitutes force majeure. Secondly, it's important to understand what does the force majeure need to lead to. Is it only leading to damage, destruction of property because of which you can suspend payment? or does it even lead to the fact that you are unable to access premises or use the premises for your own business? Is that also covered? If that is covered, then as a licensee or as a lessee, one could write to the landlord seeking suspension of payment. But if that is not covered and it only deals with damage, destruction, or it deals with the case where the property is rendered unfit or uninhabitable. Now, these things are not property being unfit or inhabitable does not mean that just because you're not able to access that the properties become unfit. Unfit and inhabitable presupposes that there is something wrong with the property and there is something amiss with the property. Therefore, it's very crucial to see what is it that the force majeure clause entails. We'll look at a few examples, but before that, we would just like to mention at least what's happening with the government, that Software Technology Parks of India, as irrespective whether there is a force majeure clause in the agreement or not, has given a complete waiver to all their licensees, lessees across India for 4 months, from March to June. MIDC in Maharashtra has given not a waiver, but has given a deferral without any penalties or interest for a period of 3 months. Even similarly, in case of under construction real estate projects, many states have suo moto taken action, such as Maharashtra, Karnataka, UP, Tamil Nadu have given a suo moto 3-month extension of registration certificates to promoters. Even in this case, now if one is an allottee in a under construction project, it cannot take recourse to this being a force majeure event and try to wriggle out of a payment obligation to a developer, because of the fact that commercial inability, job loss, or salary cuts cannot be a reason to negotiate or renegotiate terms or suspend payments under any contract. Therefore, it's important to even look at from an under construction contract perspective to see whether your agreement gives you any of such rights, or does it give a right to a developer to extend timelines of handover of possession of your flats. Now we look at some examples in commercial contracts or leases on force majeure. Can we move to the next slide, please? Yeah. So if you look at the first example, now you look at the example and you'll see that there are words like epidemic, pandemic. But if you read the entire clause, it says that the premises needs to be demolished or destroyed due to act of God, flood, war, or epidemic, pandemic. Now, though the words epidemic, pandemic are used, one cannot take recourse to this and invoke a force majeure, because it only if the property is demolished or damaged could you invoke force majeure. And because today in a present lockdown situation there is no demolition or destruction, you cannot invoke this clause even though the words pandemic, epidemic are used. Many have countered to say whether this is act of God. Now, act of God, as the courts have laid down the interpretation, it says that any event which cannot be by human intervention stopped is an act of God. And though in COVID is a situation which there is a human intervention possible, and therefore in today's construct it may not be able to be argued that this is purely an act of God unless going forward the court expands the definition. Now, if you look at the second illustration, though if you will see that there's no words epidemic, pandemic, but there's a fast sweeping statement which says that you are unable to use premises for any reasons beyond control of party. Now, even though though the words epidemic, pandemics are not used, this is a far-reaching clause which will give you a right to invoke force majeure because you are unable to use premises for a continuous period of 15 days. So these are in a nutshell what one needs to look for in any real estate contracts. And I think with this, we can move on to the next slide for employment.
Thank you, Harsh, and thank you, Kingshuk, for that very enlightening talk on force majeure. Before we really move on to employment, I would request you to address a few questions around force majeure. So the first question is really there is a scenario presented which is as follows: that if a supplier has an ongoing service contract with the customer, for which the supplier has annual contracts, and the contract does contain an FM clause with pandemic mentioned, and this supplier has performed all the work on a routine basis, and now due to COVID, the customer has invoked FM and terminates the contract. So in this situation, what happens to the outstanding invoices for services which have already been performed before the customer invoked FM? is the customer then liable to pay for those bills, or by invoking FM, the customer can deny the payment of those outstanding invoices?
Yeah. So that very good question, Neha, and we are seeing a lot of these cases where parties are, avoiding making payment for those services are rendered or goods have been supplied. Uh, uh, while of course we would ideally like to look at the clause and then advise on something like this, but um, from what you say, it appears that the force majeure clause has been wrongly invoked by the customer in this case, and the customer is
Mm-hmm.
really avoiding payment, using the force majeure clause to avoid payment. Um, and
Sure.
really, a point that we need to understand is that, look, force majeure clauses are applicable to obligations that really are applicable post the occurrence of the force majeure clause, and not to past obligations or liabilities. So payment obligations that have already accrued can't be avoided because of COVID-19.
Sure. Thanks, Kingshuk, for that. But I will also caveat, and I think Kingshuk just mentioned the point before, that in this particular situation, since it's a very specific instance, it would be ideal that somebody who understands law actually reviews this kind of an agreement, and basically the concerned party acts accordingly, because in an agreement there could be certain points that are just understood by people or who understand law better, so lawyers, and hence the recommendation really would be to get this particular agreement vetted and then act in accordance. Thank you, Kingshuk, for that. The next question is, what happens if pandemic is excluded as a word, but business impact due to government is included? Then in such a case, this force measure can be applied in today's case.
Yes, so if the obligation that is impacted on account of the government lockdown or the government order,
Mm-hmm.
then
Mm-hmm.
even though pandemic may not be included in the definition, and if government order or government action is included, you can claim force majeure.
Mm-hmm. Okay. And the last question on this topic that we've received is asking us that the particular contract or the agreement has everything that is needed in terms of force measure, and all the terms and clauses are in place in terms of language. But so can a FM be invoked, especially if the government has put this particular business in the category of essential services? So what happens then? Can the agreement, can the FM clause still be invoked?
So I think if your activity that you're supposed to perform under the contract is excluded, then it becomes a little more difficult to claim force majeure, especially on the ground of the government lockdown. And as I mentioned during my presentation, in these cases we will have to specifically spell out what is the cause, or rather, what is the reason that I'm not able to perform. And really, it will depend on those reasons as to whether you can claim a force majeure or not.
Okay, so we cannot give a blanket yes or no answer to this kind of a question. We will have to look at the specific cases involved, right?
Yeah.
Okay, thank you. So just keep the questions flowing in. We will take them as they come. With that, I would request Anshul to kindly take up the topic on employment laws. Over to you, Anshul.
Thank you, Neha. Hi, everyone. Very good afternoon. And to quickly put the perspective in place in respect of workplace management issues in the COVID-19 backdrop, it will be important for us to consider whether what we have been really looking at from normalcy standpoint actually needs any kind of revisiting. So the first bit is about remote working as a matter of policy. So I think the only document which has been there from an Indian law standpoint was the Maternity Benefit Act, which did talk about enabling provision to allow female employees to work from home during the during the period when they are required to take care of the child. But I think in the COVID-19 times, it is something which is of paramount importance for organizations to really consider whether working from home is going to be a new normal and what protocols you need to adopt if at all the employees are going to be required to continue to work remotely and contribute remotely. It is also important for us to consider whether reduced work hours and proportionate reduction in wages could be something which may be agreed by way of a written contractual stipulation or a policy document, instead of thinking in the current times where it could be a matter of concern given the current advisories which are in place. And I will get to the advisories and the current judicial perspective later. But important perspective is also the fact that practicality of working from home as an option also needs to be assessed, not just from the perspective of service sector establishment. It is also imperative when it comes to manufacturing setups, when it really becomes imperative for you to assess whether the employees who are required to work on the shop floor are unable to report, and how do you really deal with that situation. Enabling the perspective of non-core staff in the current COVID-19 times is equally important. Whether you need the core staff alongside the non-core staff, which could be the outsourced workforce, outsourced employees, it is important for you to consider from a policy perspective to revisit your outsourcing agreements, your current services agreement, to ensure that whether we are looking at any minimum guaranteed payments to the contract workers who are currently not deployed on your premises because of the lockdown situation, or even post lockdown when you are working on a reduced headcount basis, whether there is any possibility of having to pay to the contractor any kind of minimum payment vis-a-vis the contract workers. Data security and privacy breaches are something which needs to be one needs to be mindful of. You need to really revisit, look at the current confidentiality obligations. Be mindful of the fact that employees need to be reminded of what they need to do and what they ought not to do while they are working remotely or reporting to their line managers remotely. Perspective of whether they are fulfilling the requirement of a complete day of work, and while they are transferring any data or transmitting any data to a private browser is equally important for one to consider from a policy perspective. Use of company devices, the manner in which they are going to be really utilized for the purpose of rendering any of the duties and responsibilities remotely needs to be appropriately captured in the policy document. Moving on to the temporary shutdown scenario, at least looking at 3rd of May as a possibility where in the COVID-19 times the government may allow, except if you're falling in the containment zone or hotspot area, which is being notified from time to time by local administration and state governments. It will be important for you to look at the business continuity perspective, whether we are looking at only a temporary measure, or is it going to be a case where cost factors are going to be kept in mind from a long run perspective, not just from a perspective of 3rd of May or 30th of May, but even beyond it. So from a manufacturing establishment standpoint, I need to be very clear that layoff or retrenchment are two different concepts. Layoff is used very commonly these days in the media, so be mindful of the fact that from a labor law perspective, layoff is only dealing with temporary suspension of service. It is not termination of employment, and that is only applicable to industrial establishment which has 50 or more workmen who are currently deployed on the premises. And in that case, if your establishment is under lockdown or you are unable to grant or assign any work to the employee, then in that case, for all non-managerial personnel, you can really look at layoff as an option under the Industrial Disputes Act. Ongoing redundancy plans during these times, whether it is 3rd of May or even in the extended lockdown perspective, please be mindful of the fact that somewhere we have to realize that there are on-ground sensitivities, emotions are running high. If you're looking at exit, especially from a non-managerial staff standpoint, you need to be looking at the functional responsibilities, not just because there is COVID-19 times and you are facing economic hardships, but also whether there is any specific reason you can attach to when it comes to discharging an employee on a simpliciter basis. Yes, if there are disciplinary grounds, disciplinary actions which are being contemplated, provided you follow the due process of law, you are within the safe zone if you're taking immediate disciplinary action against a concerned employee, whether it is managerial or non-managerial. The concept of no work, no pay as a principle will not apply in cases where whether it is a factory worker or whether it is a worker on or a non-managerial staff in your commercial premises. For any instance, the no work, no pay principle will only apply if at all the employee is not reporting to work on his own volition for reasons attributable to him. So no work, no pay as a principle can be applied in those cases. Other than that, the Supreme Court in some judgments have already held that in these kind of scenarios where you are under complete lockdown or the employer fails to assign any duties or responsibilities to the concerned workmen or employees, the principle which will apply here would be of reduced wages or at least some subsistence allowance which can be paid to the employees. Needless to mention that to the extent you are following the process which is set out in the law, or from a contractual standpoint when it comes to managerial personnel, reduction in wages is possible. I'm going to cover very quickly the aspect of advisories and Union Home Ministry order in the next slide, but thought it best to bring up this point in the slide which is present before us. Of course, we need to be mindful of standard operating procedures which are going to be or which have already been issued by the Ministry of Home Affairs, which are being followed by almost all the state governments with some more nuances to it. So be mindful of it. I need to make it very clear that strict criminal liability, which was earlier the case or at least an apprehension for managerial representatives, once you resume operations and if there is a symptomatic employee on your premises, please be mindful of the fact that there is no immediate consequence in terms of strict criminal liability being imposed on you. Yes, there are some obligations on you to report such symptomatic employee to the nearest quarantine center. You need to ensure that there are enough facilities to the extent possible. If at all you have to immediately quarantine that individual until the health authorities arrive on your premises. So local instances, local notifications have to be tracked so that there is nothing which is really coming on to you as a managerial person or otherwise in terms of non-compliance of the SOPs. For extended lockdown requirements, one of the most critical and crucial questions which have been coming up all throughout is about new joiners or potential candidates who have already accepted your offer of employment and he has resigned, let's say, so that is the other way around, and he is about to join a new employer. And in both the circumstances, when an employee comes to you that I indeed resigned, but my new employer has told that my offer has been rescinded, can I withdraw? Now, withdrawal of resignation, given the fact that the employer has already accepted the resignation, in the current circumstances, it is absolutely discretionary for you to continue with that employee or extend his notice period. The other perspective is if you have made an offer to a potential candidate and you want to resign that offer, there is no automatic liability which will accrue to you as a potential employer, provided the employment has not yet commenced from the perspective of that potential candidate and the offer letter clearly has a commencement date spelled out. Of course, from an emergency protocol standpoint, and we have also heard from the Union IT Minister, at least from the perspective of services sector where it involves maximum use of IT devices and resources, it may be seen to be a more extended period. So it will be important for employers to also have appropriate number of helplines where employees can reach out to, whether it is HR or industrial relations perspective. Any issues or grievances need to be addressed, whether it is through telecom or through virtual meetings. Blocking yourself completely from a management perspective may not really help in the current circumstances. Accounting, payroll, social security obligations, to the extent these have been relaxed, these needs to be kept in mind that to the extent we are talking about regular payroll requirements, those are not compromised in the current circumstances. If at all there is any interruption, that interruption to the extent possible may be communicated through electronic modes. The law is pretty much clear. Even if you want to notify the employees about change in terms and conditions of service, this is very much doable. But from an industrial disputes act standpoint, whether it is a services sector or manufacturing sector, you need to follow certain processes when it comes to reduction in wages. Either it is an advanced 21 days notice or a deemed or express consent from the employee when it comes to the non-managerial workforce. For managerial employees, you also need to be mindful of the fact that although they are managerial services in nature, but there is a contractual stipulation and unilateral arbitrary reduction in salaries or unilateral change to the terms and conditions of employment may not be a desirable proposition. However, the managerial employees do not have recourse to labor courts or labor authorities in terms of how they have to deal with any proposition to reduce wages. Long-term redundancies or perspectives have to be kept in mind from a contingency planning standpoint. If there is any perspective or proposal to have headcount reductions, be mindful of the fact that there are sensitivities on ground. There are overzealous labor authorities who are looking at employee complaints in a different fashion altogether. So if you want to go ahead with any retrenchments or redundancies at this point in time, don't keep 3rd of May as a benchmark, because ultimately from a management perspective, you have to maintain a balance. One is about the business interest and another perspective is about maintaining the employee interest at the same time. So can you move on to the next slide, please? Very quickly, in terms of redundant salary components, so when we are talking about reduction in wages, I will very quickly touch upon the Union Home Ministry order of 29th of March, and which is the root cause of all the problems. And of course, we are aware of the fact that Supreme Court has recently issued a 2 weeks notice to the central government to come out clear in respect of how they want to really impose this as a requirement for the entire private sector without having any scheme or plan in place. So the view which we have taken as a firm is that Disaster Management Act's very objective is to contain, manage or prevent disasters or epidemics. We are dealing with a pandemic situation on a nationwide basis. The Disaster Management Act can override local rules and regulations to the extent they are insufficient to serve the very purpose of the Disaster Management Act. And in that sense, if somebody has to take a view that Disaster Management Act would have a completely overriding impact on the extent regulatory label of framework, that will be a misnomer. That is grossly misinterpreted. The Supreme Court in its recent order has not given any relief to the workers when it comes to the petition which they have filed. So it is very clear that constitutional validity of MHA order needs to be tested with time. But given the fact that we have to read the MHA order in its totality, please be mindful that the preamble of that Ministry of Home Affairs orders, whether it is for private sector or whether it is for the public sector, applying to them equally, was primarily based on the perspective of migrant workers. And the situation arose because of the unprecedented movement of migrant workers to their hometowns on foot, which defeated the very purpose of social distancing. So I think let's not blindly apply our minds because there is an MHA directive or an order. We have to be mindful that whatever we do, whether it is COVID-19 or otherwise, these situations, whether it is reduction in wages, whether you are looking at employees to be retrenched, you have to follow the process of law. You have to ensure that employees are taking into confidence. You have to ensure that you're reaching out and any arbitrary or unilateral actions are avoided. So that is something which you need to be ensuring from a management perspective. But of course, there are nuances. There are trade unions. There are specific contact worker related issues where contact workers may have been on your premises almost in perpetuity. So dealing with all those issues is something which is important, and a nuanced approach is required in terms of reading between the thin lines of your current stipulation when it comes to your services agreements. So in terms of advisory versus law, I've already covered this point. Wages and workforce reductions have to be dealt with cautiously, and the process of law in terms of having appropriate documentation would be the key. Communication will be the key. Reaching out to the employees will be the key. But don't please get bogged down by the advisories which are currently in the air. Don't rely on WhatsApp messages. Don't rely on opinions which are floating in the air. Take a nuanced advice. Look at a clear perspective on where the law stands currently and what Supreme Court has really said in terms of simply relying on the headlines of newspapers or media report which says that MHA orders has not been stayed. So please take a nuanced approach and then take a step further, whether it is COVID-19 times during the lockdown situation or post lockdown scenario. So with that, I would end my presentation. Happy to take any questions.
Thank you, Anshul, for that. While what we'll do is, I'm conscious of time. I'll request Abhimanyu to please take his session, and post that, provided we have time, we'll go back to the questions. Abhimanyu, over to you.
Thank you, Neha. Good afternoon, everyone, and hope all of you are safe and well at this time. My section is on corporate governance, and corporate governance is a subject and topic that is much talked about today, and the robustness of an organization's corporate governance mechanism and capabilities will be tested like never before. This is a critical, the board has a critical leadership role to play at this time, and that includes providing guidance and oversight on the company and respond to the rapidly evolving situation. It's almost like walking a tightrope act, because at one end you have to balance the fiduciary responsibilities of the company, and on the other end you have to think out of the box to navigate the situation which is in place before yourself, and pivot tested ways of doing business. But at the same time, this is an opportunity for organizations to streamline themselves, focus on what they are doing better, what they can do more efficiently, and look for areas where they can improve upon. So this is an opportunity for the boards at this point in time to band together and to figure out optimum ways of utilizing current resources. The regulators, whether it be SEBI, whether it be the NCA, have also come to the forefront to assist businesses in relaxing certain regulations, in helping them to tackle the current situation. For example, board meetings, shareholder meetings can now take place through audiovisual means. And board meetings for most matters could take place through audiovisual means in the prior situation also, but there are certain matters that the boards could not do in an audiovisual medium. They had to be physically present. The regulations have been relaxed to that extent, and all matters can now be deliberated by the board at a virtual meeting. So from that perspective, the board is encouraged to meet far more frequently to navigate and monitor the situation. The board also is in a position to set up a special task committee, which can meet even more frequently to navigate the situation. The regulators have also been kind enough to take certain other measures, which will surely give a breather to the internal finance teams of various companies as well as auditors. CARO 2020, which was supposed to be applicable from this financial year, has now been postponed for 1 year. This is a huge breather which has been given, because the time that would have taken for companies to take care of this new regulation for its accounts would have been quite difficult, given that all of us are currently working from home. The government has also released a settlement scheme for various delays in filing of forms by companies. This scheme is open up to September 30th. So any company which has delayed in form filings can file these forms with just paying the late fee and without incurring any penalties. This is a great one-time opportunity for all companies which have delayed filings to catch up with their data, file it with the regulator, and become compliant. Certain other relaxations that have been provided for listed companies include filings under the takeover code, which had to be filed annually as of March 31st, which has been pushed to June 2020. Then filing of annual and quarterly results have been pushed to June. The shareholding pattern, which had to be filed for post-March, has been pushed to June. Sorry, pushed to 15th of May. Some exemptions have been given for publication of advertisements, which had to be given for shareholder notices, etc. That has also been pushed to 15th May. We'll see whether that gets pushed further given the current situation. But as of now, there is flexibility to not publish newspaper advertisements for certain things up to 15th May. There's a requirement for prior intimation for board meetings for certain things. That has also now, that prior intimation require at least 5 days or 2 working day period for certain things. That has been uniformly reduced to 2 days. The other important flexibility which has been given by the government is in usage of CSR funds. Now, CSR funds, as you know, have a particular source in which you can, particular avenue in which you can deploy. Now that has been liberalized during the COVID situation. The usage of CSR funds is now permitted for activities promoting healthcare, preventive healthcare, sanitation, and disaster management, which is related to COVID-19. There are certain things which are eligible for CSR, which include PM CARES Fund contribution to state disaster management authorities to battle COVID, and ex gratia payments made to daily wage and temp labor. What is not eligible for CSR essentially are any contributions to CM relief fund or state relief fund, payment of wages or contractual or statutory wages to employees and other daily wage or temp labor. Neha, can we move to the next slide, please? The other important consideration for listed companies is that given the COVID situation, most companies are going through a difficult time, which could lead to closure of certain units, which would lead to termination of certain contracts. We just heard about force majeure in our presentation. Some companies could be at the receiving end where certain contracts are terminated. Accordingly, the company has to make these disclosures to the stock exchanges on an immediate basis. All material events should be disclosed as and when they happen, and no later than 24 hours. The disclosure should be clear, should be straightforward, without using any boilerplate or generic language, so that the information is out there in the market and disseminated to various stakeholders, including the investors. The other important aspect is navigating investor calls. I'm sure, as you would have seen, for the issuers who did investor calls as of January and February, COVID-19 was still a far time away at that point in time. So the investor calls at that point could not even envision a situation like this pandemic, which is currently taken hold on us. So from that perspective, a lot of companies gave certain business projections as what they would be doing in the next quarter and for the rest of the year. So most of those projections will have to be revisited at this time. It is doubtful that the companies, given the situation, can give any concrete guidance to the market as to what they will be doing. And a lot of their guidance would be qualitative and would be subject to the current the unfolding situation at hand. The other important aspect that we are seeing at this point in time is that because of the stock market volatility, certain stocks have become fairly attractive, which could pose takeover opportunities. And as you already know, the government released the press note 3 in relation to opportunistic takeovers, which has prevented certain of our neighbors from purchasing stock without government approval. And some of these measures may also become accentuated as the situation evolves. The government has also released another notification which prevents foreign investors who are renouncers in rights issues to purchase at a price which could be higher than what the company has set for its shareholders. So from that perspective, the certain measures are being taken to, I believe, from a government's perspective, to protect the Indian stakeholder interest. This situation also presents an opportunity for promoters at this time to consolidate their positions, if at all, through creeping acquisitions. Stock prices are fairly attractive at this point if any promoters group wants to do that. From a buyback situation as well, if there are issuers who are looking at issuers and companies who are looking at a buyback scenario previously but were dissuaded because of the stock price, and find it favorable to go and do the buyback if they are sitting on cash which they feel that they should return to investors. And thirdly, delisting is also a scenario which companies may look at. because of the stock price coming down, and delisting otherwise would have been complicated, but given the current valuation, they may find it favorable. So these are some of the situations that we are looking at with our clients as they are navigating the COVID waters, so to speak. And we will continue to keep our stakeholders updated as the COVID situation evolves. Thank you, Neha. Over to you.
Thank you, Abhimanyu, for that session. I am quite aware of time. However, what we could request, and Nilay, please let us know if it's possible. Can we take another 7 minutes for questions?
Yeah, sure.
Okay, thank you. So there are a few questions that have come our way on especially the real estate and employment piece. So I'll begin with the real estate piece first. So Harsh, the question is as follows, and I think they have pasted something verbatim, and I'll read that out to you. It says that if the lease mentions the follows: if due to flood, fire, earthquake, tempest, or any other acts of God, or for any reason beyond the reasonable control of human beings, the premise or any part thereof cannot be used and or occupied by the lessee, or if the premise or any part thereof is sealed or is rendered unfit for use and occupation by any statutory authority and or municipality, the lessee shall not be liable to pay any rent or any other amount whatsoever to the lessors for such period. So in this case, is the company liable to pay rent, or they can avoid paying the rent?
Yeah, so in this case, the company can avoid paying the rent because two things are important in this whole thing, that there is a line which says if anything which is beyond human control, and it also says that if the party is unable to use or occupy the premises. So these two are critical things, and they can on basis this avoid payment of rent. But the right approach would be to first write letters saying we are invoking this and therefore we will not pay rent.
Okay. The next question is as follows: that if the lease deed does not cover pandemic or epidemic words specifically, but does cover any act which is beyond the control of both parties, and the FM clause also covers government regulations specifically, then in this case, can a reduction in lease be claimed?
Yes, so that means that if it's covering government orders, that means that force majeure event contemplates the present situation. Now, what that person will have to look at is what is the consequence, whether it leads to termination, suspension in rent, does the contract provide for it? If it does, then they can absolutely invoke it and take it forward.
All right. The next question is, can a legal demand for waiver of rental fees for lockdown period be made, since there was no usage of the premise, and the contract essentially becomes impossible to perform during the lockdown period?
Correct. So, however logical this is, that the fact is in a case of a lease or a leave-in license, use is the most critical part. But the way the Indian courts have interpreted this is that unless it is extremely explicitly mentioned in a document that for reasons beyond control or for reasons if one is unable to use premises, then he will have an option to suspend payment. Unless this is mentioned in the contract, it's not possible. You can write letters, but if this reaches court, then it may not be possible to sustain this.
Okay. So I'll now move on to questions on employment. So Anshul, the question is as follows, and it means, would work from home mean using the premise for commercial purposes? If yes, then would the person be required to obtain any kind of commercial license for use of his residential property for conducting a commercial activity? And also, are there any acts or regulations in place to cover this scenario?
No, absolutely. We have to. Thank you, Neha. Very good question. And first of all, you have to look at it from the perspective of somebody who's carrying out a business or activity being the owner, or somebody who can be called an employer, rather than a person who is trying to render some services which have been required to be rendered on his part by the employer per se. So as a company, you have instructed the employee to work from home. And to the extent those services are rendered from home, it does not necessarily mean that the premises from where he is rendering services, especially from a residential premises, will be deemed to be a commercial establishment. And if that is the case, it will have a far-reaching consequences unless and until tomorrow we have a different legislation in this regard, that each and every location where residents are there and they are working from home will be considered to be a commercial establishment. So we have to differentiate between where an employer is operating from and where an employee is really operating from.
And employees of it. Okay, understand. One last question before we close. Anshul, the question is that if somebody has received a pre-placement offer and this offer was preceded by a period of internship which has been fulfilled, then in this case, can the PPO still be cancelled?
No, so as I have mentioned that there are instances where the offer may make it clear that one is internship, because internship is not an offer of employment. That is just an opportunity given to a person to acclimatize himself or herself to the current work environment, and you also get to see if the person is fit enough for the job. But the moment it comes to an offer of employment, you need to really be mindful of any specific conditions or stipulations which may be there for a commencement date. Commencement of internship does not necessarily mean that you have already commenced employment. You need to rely on the contractual stipulation, and then one can conclude that offer letter and its acceptance does not necessarily trigger employment obligations between two parties. The contract is still in the making. If the concerned employee has not yet joined the services, then it will not be deemed to be a full contract.
All right. Thank you, Anshul, for that. And with that, we do come to a close today, and we hope you found the session useful and interesting. We would definitely like to receive your feedback on this webinar, and a short poll will now appear on your screen. This poll will be available to you for 30 seconds. Please select an option by clicking on your screen. And also, once the webinar is closed, you will receive a short survey that will open up in your browser. We will also be grateful if you could fill that in too. So thank you for this lovely audience today. I would now request Nilay to kindly provide us with his closing words.
Yeah, thanks, Neha. So on behalf of Dalal & Broacha, I would like to thank all the participants and the partners at Khaitan & Co. for their valuable time to take us through this session. Dalal & Broacha constantly endeavors to assist our clients' investments through these turbulent times. Today's webinar is just another event along with a series of web series on investing in crisis that we have made to help our clients, in these turbulent times. Once again, I thank everyone, and please stay safe.
Thank you from Khaitan & Co. Please stay safe from our side as well.
Thank you.